Hey, everybody. Welcome to True Crime Wednesday. For those of you who might be new to the channel, my name is Lori Hellis. I'm a retired criminal attorney, and we talk true crime every week. Same time, same place. So while we allow people to filter in. I want to say hi to Julie. Hi, Julie. Hi, Susie. I see you guys. Hi, Jackie. I see you guys in the chat, and welcome. And I want to talk. There are a couple of small things to talk about before we really dive into Sarah Boone and Delphi, which are the two cases we're going to talk about tonight. One is Lori Vallow's attorneys in Arizona. Her attorneys in the Arizona case having to do with the conspiracy to murder Charles Vallow and Brandon Boudreaux. Both of those cases are pending. Actually, they're being heard as one case. They were originally filed under two indictments, but it's being tried as one case. Her defense attorneys in that case have asked for a competency evaluation. I really think that they're going to get a competency, a psychologist is going to come to the same conclusion that they came to in Idaho, and that's that she is competent to stand trial, that the fact that she has religious delusions don't preclude that. I'm wondering whether this was in some way triggered by Colby's publication of his interview with her. But truthfully, she sounds pretty cogent and pretty competent and pretty much oriented to time, place, and her circumstances in that interview. And I don't know that there's any hope that they're going to find that she's not competent to stand trial, particularly since she's had a history of evaluations, and she did have a history of a period of being incompetent, but she continues to be on medications, and I don't know. I didn't hear anything in Colby's conversation with her that was concerning to the point where I would say, wow, I'm worried whether or not she's competent. And we know that religious delusions aren't enough to find somebody incompetent. So we'll be waiting to see what happens with that. Her trial isn't set until next year, and so there's plenty of time for them to do that evaluation without impacting her trial any further. So some of you asked me, because I posted on Facebook that I was baking bread, which I absolutely love to do, wanted the recipe. So I am going to post the recipe in our show notes. It's a very simple recipe, and I thought in between talking about Boone and Delphi, we might talk a little bit more about this rustic bread loaf that I've been making. So, but I wanted to let folks who might be joining us join in, because they may be the ones who asked about the recipe. So, but we will post it in the show notes. It's very straightforward, very easy, and I'll make sure I add it in. So let's jump right into Sarah Boone. So we've had a week of watching Sarah Boone, watching the prosecution initially put on their case. The prosecution's case was fairly straightforward. They put forward the videos and the a few witnesses who saw uh, lived near Sarah and George and heard them fight. Some witnesses who lived right next door and heard arguments and noise. um, there was a lot of legal positioning and legal battles back and forth, legal wrangling about whether or not the battered spouse or intimate partner violence defense could come in. So the prosecution was very clear that they didn't want that information to come in because they felt like it was um, they didn't want her to raise the defense, and the defense was very clear that they were going to go forward with that defense if at all possible. So one of the arguments was that the argument was that under the Florida case law, that in order to raise the battered spouse defense, there has to be an inciting event, a triggering event, and what they classify, the case law classifies as an overt act, meaning that you can't just put on that you have a history of this person abusing you. You also have to put on that on that day, in that particular incident that led to the defense, that led to the abused person defending themselves, there had to be an inciting event. There had to be an overt act on the part of the abuser that triggered the defendant to defend themselves. It's not enough just to show that this person had a history of being abused by their abuser, and that for that reason they had a heightened sense of fear or of concern. It's almost like a two-part test. First of all, you have to be able to show, well, it is a two-part test. First of all, you have to be able to show that there has been this history of systematic violence that caused your client, the defendant, to be in fear for their safety, where a reasonable, ordinary person might not have been because they didn't have that history with that abusive person. Then there needs to be this overt act, this inciting incident that causes the defendant to make the choice to defend themselves. Hopefully that makes sense. So all along, the defense has been saying that the overt act was the fact that George was putting his hands outside, or a hand outside of the suitcase through the opening where the suitcase was unzipped. And he was making threatening statements to Sarah about what he was going to do when he got out of the suitcase. Now, what the defense says, and this tracks, is Sarah makes the first longer video. Then there's a roughly 9-minute period where there is no video. And then there's the brief video where all you see or hear is George say, Sarah. And that between those two, there was this period of time when Sarah alleges that George was making threatening comments to her, and that the whole situation had flipped from being fun and games to being, when I get out of here, you're going to be sorry. So initially, the judge said there is not enough evidence. There is not enough of an overt act identified for me to make a pretrial ruling. If the defense is able to show the overt act, then the door is open for them to put on the battered spouse um, information. So it really was pivotal that Sarah Boone take the stand and that Sarah Boone follow her lawyer's advice, that she not become a loose cannon, that she remain um, restrained, and that she keep her answers short, and that so Sarah Boone's testimony became pivotal because that was the only way for them to begin to show that overt act so that they could bring in all of that battered spouse information. So Sarah testified. The prosecution put on all of their CSI type witnesses about the scene, about the investigation, about the phone extractions, about all of that information, and they rested. And so the defense then, one of the things that you never want to do, and one of the reasons why it felt really uncertain in the earlier arguments about the battered spouse defense, is you never want to promise in opening statements something you cannot deliver. And so for the defense to get up and say Sarah Boone's innocent, she was a battered spouse, she was a victim, they had to be very sure that they were going to be able to get that information in about that overt act, about that about the triggering event. Well, so they took over after the prosecution rested, and they put Sarah on. And she was, I have to say, now I want you to remember that the jury is only seeing what is within the four walls of this courtroom. They have no access to any other information. They do not know Sarah had 8 other lawyers. They do not know that she inundated the judge with letters, and that she was difficult to deal with, or that she was demanding. They don't know any of the things we all know about Sarah Boone, the person. What they know is what they saw within the four walls of that courtroom. So one of the things that her attorneys were able to do with preparation was to, and with proper questioning, was to keep her very, very carefully hemmed in her answers and in her descriptions. Yes, there were times that she said things that were unpleasant or unfair to George. Yes, there were times that she said things that were victim blaming and those sort of things. That is very much a defense strategy. So it didn't surprise me at all. And particularly in the instance where you are making a defense that your defendant is actually the victim. So I thought that, knowing what we know about Sarah, that she and her lawyers both did a very good job of presenting the battered spouse defense, presenting what Sarah claims happened to her, and presenting information that would then allow them to bring in all of the experts. So I thought, um, additionally, their experts were very good. Their expert who talked specifically about battered spouse did a good job, and the psychologist who actually interviewed Sarah and did a quite in-depth evaluation of her. I mean, she saw Sarah 9 times. That's a lot more than most evaluators do. Um, so I think that could her attorney have done more, had they had more time? Maybe, but I think that her attorneys did a very good job. They did their case did what they needed it to do. Now, does that mean the jury is going to buy that and that the jury um, is going to believe their version of events? I don't know. So where we are now is that um, the defense may have one more witness. I know that there's some they want to make sure that they have all their trial exhibits in, and they also want to make sure that everything's been properly marked and admitted and all of those things. And but it's possible they'll rest tomorrow morning, and then the prosecution will come and put on their rebuttal case. Now we don't know what's in the prosecution's rebuttal case, so there may be rebuttal that begins to paint George in a different light. It may paint George as being victimized. So here's the thing: just because Sarah also was sometimes an abuser or sometimes victimized George does not negate that she was um, suffering from battered spouse syndrome. So it can be both things. And I think that's what you're going to hear the defense argue, that it is not, this is a human relationship, and it is never completely one sided, where one's always the aggressor and one's always the victim. That is not human nature. And so it is possible that the prosecution can come back and say, but yes, but look at all the times where George got injured. Um, and the defense's argument is going to be okay, but that both things can be true, and Sarah Boone can be not guilty because of this self defense argument. Um, I know that a lot of people don't want to hear that, but my job is to explain the law and how the law intersects with these particular cases. So I think I think both sides did a good job. I thought the prosecution did a good job. I thought their opening statement was quite clear and laid out the facts very clearly. Um, their their understanding of the facts, and I think that her defense team has done a pretty good job. Now there have been a couple times that I've thought, what are they thinking? They're not. It's so easy for somebody who is baking bread in their kitchen while they're listening to a trial to say, "Oh man, they missed that objection, missed that answer to that objection." And it's much harder when you are on the spot and thinking on your feet, and your mind is going 17 different directions, trying to think about what comes next and what witness is next and have they been delayed, and at the same time trying to figure out what the exception is to the hearsay rule. So one of the arguments, and it was funny because eventually the prosecution backed down and they came in. But late today, there was an argument over they were asking the court to take judicial notice of two no contact orders. Now, it was not clear to me who was the moving party in these no contact orders, whether Sarah was the moving party or it was George. Either way, there was a good argument to bring those in, even under the hearsay rule. So, first of all, the state was saying, well, it's hearsay because these are documents that are where there's no one testifying about the veracity of the documents or what's in them. Okay. So typically, if you have a certified court order, an order from a court, it is self-authenticating, basically. You don't have to have the clerk of the court come in and say, yes, this is a valid court document, because it's presumed to have indicia of reliability because it's a court document, and they're considered to be self-authenticating. So why they didn't take that tack to begin with, I don't know. Florida law could be different than other states that I'm familiar with. So the next thing that happens is that the state says, even if you let it in, it's hearsay. So then we have to ask ourselves, well, does it come in under an exception to the hearsay rule? So there is an exception to the hearsay rule for official documents, right? For business records, it's called. But usually that requires that the custodian of the records has to come in and say, yes, this is, for example, if you're trying to introduce corporate records of corporate books in a civil case, you would have to have the custodian of records come in and say, we keep these records in the ordinary course of business. Everybody keeps these similar kinds of records, and it is these records, we do them the same way every time, and they are a business record. And if that is the case, then they come in under the hearsay exception, because the issue is, how do you authenticate these documents if what's contained in them is compiled information by a third party? So, but the next question is, are the statements that were made to get those no contact orders, are they hearsay? So one of the things that I didn't really understand is that typically when somebody goes in to get a no contact order, a restraining order, they go in and they give a sworn statement. They go before a judge or a magistrate, and they explain to the judge why they need this order. And that person, before they tell the judge that information, are sworn in, and that is sworn testimony. So sworn testimony can be introduced because of, again, of that indicia of reliability. So the first step is it's sworn testimony. So then, is it really hearsay? Well, there are exceptions to the hearsay rule. And one of those exceptions is a statement of the party. So the defendant's statement is not hearsay. So if these are Sarah Boone's sworn statements for the purpose of getting a restraining order, they come in because they're her statements. On the other hand, there's also a hearsay exception when the deponent, the person who made the statement, is unavailable because they're deceased. So the two things that happen are, first of all, I would have argued, because these are sworn statements, they clearly have an indicia of reliability. They're self-authenticating again. And then if they're George's statements, they come in because he's unavailable because he's deceased. If they're her statements, they come in because they're her statements and she's a statement and she's a party. So it was interesting to watch them kind of fumble through that because the defense attorney who was fielding the objection didn't get there. In the meantime, they did say, well, we have the judge was saying under the rules, it may not be self-authenticating unless you bring in the court clerk who can lay the foundation for why this is a reliable document. And so then Owens stood up and said, well, we have that clerk under subpoena, and if you'll give us until the morning, we'll arrange to have that clerk come in. And at that point, the prosecutors said, oh, well, we don't want to put the court clerk out. We'll just stipulate that those documents come in. So after all that sort of flailing around with the hearsay objections, then they decided, well, we'll go ahead and agree to let those documents come in. I don't know that in the grand scheme of things, what they're going to be able to show with those documents. So, but it's clear that there were no contact orders. And since I couldn't see the documents, I don't know who actually, who they were actually protecting, whether it was Sarah or whether it was George. To me, it doesn't really matter because, as I've said, both parties can at different times during their relationship be victims, and yet Sarah Boone still still have this brand of post-traumatic stress disorder that we call battered spouse syndrome. So I thought that both of the experts that the defense put on were excellent in explaining what battered spouse syndrome is and why, and then for the person who actually evaluated Sarah, why Sarah qualifies under that the definition of that diagnosis. So they were all very quick to point out that battered spouse syndrome is not a diagnosable condition that is in the DSM-5. That's the diagnostic and statistical manual that all mental health professionals use to diagnose patients. It is not a diagnosable. It is not a diagnosable condition. However, they were both quick to point out that it is a brand of post-traumatic stress disorder. And the fact that the person has this very heightened sense of fear and the hypervigilance and a lot of different other symptoms that go along with it, that they are more likely to lash out and defend themselves. And it may not be at the most rational or reasonable time. Now, really, this diagnosis comes out of some studies that were being done in the 70s, which Sarah Boone's evaluator talked about, when there was a psychologist who was particularly interested in why women don't leave their abusers. And at that point, it really was primarily directed at women. Why don't women leave their abusers? As time went on, it was clear that in the cases where a battered spouse had defended themselves, acted in what what was arguably self-defense may not have looked exactly like self-defense in a lot of other cases. So, um, in the instance where somebody is pointing a gun at you and you shoot them first, or they're swinging a bat at you and you shoot them, that's a clear cut. Someone is coming at you, putting you in fear of your safety or your life, and you then use deadly force. That is very classic, clear cut self defense. If, on the other hand, you have been a battered spouse for many, many years, and your husband comes home drunk one night and passes out into bed, and you sew him into the bedding and then set the bed on fire after he's beat the hell out of you when he got home, that's a little bit harder to explain as a clear cut self defense. That's where the battered spouse defense sort of arose. So it's not an easy it's not an easy measure to prove. I mean, it leaves open a lot of interpretation. Was this person really afraid for their life? And as the judge said, in Florida, there has to be that inciting incident. There has to be an overt action that triggers that person to feel that their life and safety are at risk. So I understand that a lot of people, like every one of our true crime cases, have very definite ideas about where this case should come down and what the outcome should be. And but I think that I wouldn't be fulfilling my role in this true crime community space if I didn't point out the legal um, the legal aspects of this case, because that's what y'all come for. So I do believe that based on what I have seen so far, the defense put on a pretty good battered spouse defense. Now we don't know what the rebuttal witnesses are going to say. We don't know what the state's rebuttal is going to be, and so we'll have to wait to hear about that. As you saw in the Vallow Daybell case, in Chad Daybell's case, the rebuttal was pretty robust, and they did save some things, hold some things back until for their rebuttal arguments. So we'll have to wait and see how that plays out. So before we get started on Delphi, I want to talk about my bread because a lot of people have been asking me for the recipe for this loaf of rustic bread that I posted on FaceTime or on Facebook. So here's the deal. It is super, super simple and it turns out beautiful. So here's the key. It is I'm just going to give you the recipe right off the top of my head because it's that easy. It is 3 cups of flour, a cup and a half of warm water, 1 tablespoon, no, I'm sorry, 2 teaspoons of dry yeast, and 2 teaspoons of salt. That's it. So the way I've always baked bread, although different recipes do things differently, I always bloom my yeast. So you put your yeast in with the warm water and you let that set for a minute to 3 minutes until it starts to foam. That tells you that your yeast is alive and is activated. So once you do that, then you add the 2 teaspoons of salt and 3 cups of flour. And you mix it together either with your hands or with your stand mixer until it forms kind of a sticky, shaggy dough. This should be sticking to your fingers, okay? And At that point, you put it in a warm spot, and you're not doing any shaping of this dough. It's just this sticky dough. You put it in a warm spot, cover it with a clean towel, and you let it set for 30 minutes. Okay. At the end of that 30 minutes, you wet your fingers because this is sticky dough, and you reach in the bowl and you fold what the side to the middle on all four sides. So fold one in, turn the bowl, fold one in, turn the bowl until you have folded all the sides into the middle. And you throw that towel across the top and you set a timer for 30 minutes, and you go off and do whatever it is you're doing, and you come back in 30 minutes when the timer goes off and you do that again. And you do it a total of 4 times. Okay. Now, I have found that I don't count my initial rise as a turn. So the initial rise, and then I do 4 times, so 2 hours worth of setting a timer and turning and folding your dough. Now, what that does is that allows the gases in the bread to form, and you're not really punching down your dough. You're really just sort of folding it over and allowing those gases to continue to be in the dough and to continue to form as the yeast works. Um, you want to preheat at the when you make the last fold, the fourth fold, then you want to preheat your oven to 425 degrees, and you want to put your Dutch oven in the oven to heat. So while your oven's preheating, you're also preheating your Dutch oven. So after you do the last fold, you take that hot pan out of the oven. Be very careful because it's 425 degrees. It's going to be really hot. So handle very carefully. You sprinkle a little bit of flour in the bottom of the pot, and then you take that dough. Still, you're not really shaping it. You take that dough and you plop it right in to that Dutch oven and put the lid on. No, the next thing that you do is you score the top. You can either cut it with a pair of scissors and I just kind of make an X, or you can score it with a knife or a lame blade, and then then you sprinkle it with a little more flour, and you put that hot lid on, and very carefully put the whole pot with the dough and the lid on in the oven. Set your timer for 20 minutes. And at the end of 20 minutes, you're going to reduce your oven to 400 degrees and take the lid off. And then you're going to bake that bread for another 20 to 30 minutes until it is golden brown and gorgeously crusty. It should easily turn out of the pan. I've never had any trouble getting it out of the pan. You just shake the pan a couple of times and it should loosen up in there and turn it out onto a cooling rack. You want to turn it out of the pot right away because you don't want your crust, your yummy, crunchy crust, to steam inside the pot. So you definitely want, once it comes out of the oven, you want to turn it right out onto a cooling rack. Let it cool. I have cut it warm and served it warm right out of the oven for dinner. I've also let it cool and served it later. Both work, although I think letting it cool gives it a little more time to settle and gives the crust a little more time to crunch up. And it makes beautiful, crisp crust with a lovely soft interior. And it is the perfect accompaniment for soups, for spaghetti, you name it. It is very popular in my house. So I will put the recipe in the notes so that you all can share. and post me pictures, send me your pictures, and let me know how the recipe worked for you. It's not really an original recipe. I didn't make it up. It's a pretty common rustic loaf recipe. It's called no knead bread. I don't know really where it came from, but originally, but it's very common. It's very common in northern Italy, in all Italian households. I think every Italian grandma makes that kind of bread. So there's no real secret to it. So let me know how yours turns out and post pictures in our Facebook group. And I am going to have a couple other recipes that I'll share with you as with the holidays coming up. I have a pumpkin bread loaf I shared before, but I'll share that again for anybody who wants it. Um, with all of that said, let's talk about Delphi. Now, it is interesting to me that the judge in this case, Judge Gull, Francis C. Gull, like seagull, um, has been difficult and opinionated from the very beginning. And I don't understand why she is still on this case. Fee and me, thank you so much. That's very kind of you to send me a super sticker. I don't always ask for them. I appreciate them when you send them, though. So thank you so much. Um, anyway, uh, Judge Gull has been a very, very opinionated and biased judge from the beginning. This is the judge who threw Richard Allen's attorneys off the case, and they had to go to the Indiana Supreme Court that ordered them to be reinstated. So she has a very clear bias toward the state. And I think that is going to continue to be a problem because I think it's highly likely that Richard Allen's that if he is convicted, this case is going to get thrown out. For so many reasons, for not allowing the third party culprit information in, for not allowing a lot of the defense's motions, for denying them without even hearings. I mean, her 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 behavior has been really deplorable. And I think that every lawyer that has covered this case, including the three that I've been watching carefully that are there in the courtroom covering this case, would say that she is really, her behavior has been really deplorable. So, because the deplorable judge has decided that there will be no live streaming and that there will be no release of trial transcripts or trial recordings, there is no way for anyone to cover this case except to be present in the courtroom. And that has created such a hardship. She has absolutely denied press credentials or press availability to anyone who is not a member of the mainstream press. So if you are a book author or you are a magazine freelancer or you are a YouTube creator, you do not qualify, according to Judge Siegel, as a member of the press. What that means is that the folks who we've been most interested in following, Andrea Burkhart, um, uh, Bob Motta and Defense Diaries, and Lawyer Lee, they're all having to go out at 2:30 in the morning and line up to get into court for the next day. And even at that, Andrea said she has been going out every morning at 2:30, and at least within a day or so ago, she literally there were 25 seats and she was number 24 in line. So it's an incredible hardship on the people who actually want to go and observe the trial. We saw similar crowds for the Vallow Daybell case, but they did have overflow closed circuit TV available to accommodate the crowds. And the judge did release the recordings that from each day after the close of court. So if you weren't able to be in the courtroom, at least you could get the recordings and hear the recorded uh, testimony from that day on that same day. So as it stands right now, the people who we look to be sort of the eyes and ears in the courtroom are it's been a tremendous hardship for them. I mean, like Andrea said, she comes home from court and gets her notes together and does her live stream for a couple of hours trying to explain what happened in court that day, and then goes to bed, and 4 hours later gets up and lines up in the cold in a camp chair um, to wait to get into the courthouse once court starts. And I mean, Judge Gull has made it as difficult as possible. One of the things that happens is when you leave the courtroom, when the court adjourns for lunch and you leave the courtroom, you immediately have to go back out and line up to get back into the courtroom, or you're not going to get a seat because your seat isn't saved from the morning. And up until today, the judge said there would be no food or drink in the courthouse, which meant that if you wanted to eat or drink, you had to go outside the courthouse. Now she has agreed that you can bring food or drink into the courthouse, but you can't bring it into the courtroom. So I don't know how they're managing that, and of course you can't eat or drink in the courtroom. Now, I will say in the Vallow Daybell case, they did allow us to bring our coffee in, which I thought was more than most courts would do. But people were allowed to have water and to bring in their covered cups of coffee, which the judge didn't have to do. Water, usually people are allowed to bring in bottled water, but not always allowed to bring in any other drinks. The judge voice said, as long as your cup has a lid on it, you can bring it into the courtroom. And I thought that was reasonable and fair, more than fair. So, but I think that Judge Gull is trying to make it as difficult as possible for the public, and particularly any kind of media, to scrutinize her. And she's going to make it as difficult and as uncomfortable as she possibly can for people who are in that courtroom. And that to me just continues to show her level of bias and her level of contempt for the witnesses and the system. And that I find disturbing. I find it really troubling that she has that level of contempt for the First Amendment. Because what we know about our democracy and about our Constitution is that the First Amendment is one of those checks and balances, the many checks and balances in the Constitution. The First Amendment is the way that we cast sunlight on what the government is doing in our courts. And because the government has way too much power, and we need people who are going to cast sunlight on what the government is doing and speak the truth to power, speak the truth about what is going on in the courts. And I think that Judge Gull is a classic reason why we need to protect our First Amendment, constitutional First Amendment rights. I think, if anything, Judge Gull is an illustration of that. Tiff, this is a great question. I don't know. The judge has not allowed any cameras, so even if they had an overflow room, there's no closed circuit TV camera that would be broadcasting to the overflow room. But I don't know. We've seen in so many other trials, judges handle things so differently. I mean, we saw in Adelson where it was live streamed. We saw in Vallow Daybell two different ways that the two different trials were handled. And I think there are so many better ways to do it. But this judge has absolutely um, ruled this courtroom with an iron hand. And she absolutely is aiming to suppress the press, aiming to suppress the community, aiming to suppress anyone who might come into the courtroom and criticize her. And the fewer people that can get into the courtroom and the more difficult she makes it to get into the courtroom, I think the less likely it is that people are going to be there and be critical of her and her rulings and her bias. And it's very unfortunate. I think all of the lawyers who have been following the trial for a long time continue to be incredibly disappointed, both in her and in the Indiana Supreme Court, because the Indiana Supreme Court has declined to recuse her. So let's talk a little bit about sort of the nuts and bolts of what's been going on in Delphi, as we know it, having heard from people who are in the courtroom. I think all three lawyers that are following, Lawyer Lee, Bob Mata and Defense Diaries, Bob and Allie, and uh, Andrea Burkhardt, are all doing a really good job. They're keeping really detailed notes. They're trying to um, record as much as quickly as they can so that they can come back and tell people about what happened. And so I think they're all doing a good job. Most recently, I listened to Andrea's rundown from yesterday, and I think her notes were really detailed, and some of the things that she pointed out were some of the objections and the legal niceties in the case that are of interest to us. So I thought she did a good job with that. Um, the prosecution really started with a focus on the the experts, the law enforcement people, the CSI people, the crime scene investigators, and the telephone extraction folks. So what we know is that part of the defense's argument is that I, I I don't remember which of the girls had the phone. I think it's Libby had phone and Abby used it, or vice versa. They had one phone that they shared between them a lot. Um, when the phone of extraction was done, there is a period of time, a lag of time, where the phone is not transmitting. So either it is out of the area of the trap or it was turned off. When it is recovered under one of the bodies, it is on, charged, and receiving. So it doesn't make a lot of sense that that period of time is a mystery. It doesn't make a lot of sense as to why there's that gap where the phone wasn't receiving. Because then at the time that the phone begins receiving, all of these text messages and data of the people trying to contact the girls downloads all at the same time. So the defense's position is that the girls were taken out of that area and then their bodies were returned. There, it is very clear, the defense is making very clear that this was an incomplete and inadequate investigation. That there were a lot of missed opportunities in this investigation, a lot of things that were not pursued, a lot of things that were not collected. And the defense is definitely making points, pointing that out. So there was a lengthy and detailed description of the crime scene, of the condition of the girls' bodies, of the um, of the environment around, a lot of discussion about the mechanics of the search for the girls after they were reported missing. That took up a lot of time that for some very technical and really detailed sort of information. So um, I thought it was interesting, and Andrea made the point that law enforcement said that in 2017 there were very different protocols for how they handled the phones. Andrea didn't believe that that was accurate, although Celebrite, which is the company that makes the program that does the extractions, was in its infancy at that point. It did exist, and law enforcement was using it. It probably didn't have the functionality that it currently has all these years later, but they were using it. One of the points that was brought up was that when they received the phone, they powered it on, they sorted through it, they opened apps, they did all of the things that you are not supposed to do. Because one of the things that happens is when you power up and down the phone, you run the risk of losing data that was stored in any of the temporary caches, because those temporary files get dumped once the cache is too full. Then the oldest stuff starts falling out. And so she made the point that best practices is always to immediately put the telephone in airplane mode, to put it in for to be doubly sure, to put it in a Faraday bag, which is a bag that keeps signals from getting to the telephone, so that it can't be altered remotely. And so those are all protocols that are in place now. But hi, Bestie. That's my daughter, and who is just moved into her new house. This weekend coming up will be the second weekend, and so she's getting settled into her new house in Bend. And it is such an amazing luxury after all the years of being very far away to be able to just see her whenever I want. So it's I'm a little giddy over it. It's going to take me a little while before I sort of get used to that. So, but it's lovely having them here. So back to Delphi. There's no question that the way that they handled the cell phone is certainly not best practices in 2024. I think it's arguable that they weren't really best practices back in 2017 either. Although I can't argue with the fact that the technology's improved over time. And the way that they preserve that information. One of the things that that Andrea said is that the people who were in the court finally were able to see the entire Snapchat video that that the girls took that on the bridge. From that video, we heard a man's voice. What we knew in the then was released to the public prior to trial was a man's voice that says "guys down the hill," and a photo, a still photo taken from that video of a man, either in a hoodie and a hat, or some with his head covered, with a jacket on, pockets, hands in his pockets, um, and that is the person who law enforcement called bridge guy because he was walking across the Monon High Bridge. But as Andrea pointed out, when you see that video, bridge guy is a tiny little guy in the background. He is not close to where the girls are. He is not um, this threatening figure that he appears in that still shot. The reason is because they isolated that still and blew him up. So the the bridge guy image that everyone has been seeing all this time is a large blown up version of this man walking across the bridge, and and he seems to be kind of a looming figure, or a figure that's following close behind the girls. That is not the case at all. The other thing that she pointed out, and was pointed out in the testimony, was that captured still had to be enhanced, and enhanced to the point where there's a lot of room for interpretation, a lot of um, potentially AI filling in the blanks. It was very blurry, and so the photograph was heavily manipulated in an attempt, not in an attempt to mislead anyone, in an attempt to clarify, and to make it visible enough to figure out who this person is. But it's very clear that Bridge Guy is not the central figure of this video that the public was maybe led to presume. I won't say anybody ever said that outright, but maybe it was just easy to kind of jump to that conclusion. So, um, in fact, that is a heavily um, uh, enhanced uh, version that requires a lot of extrapolation to create that image. She also said one of the interesting things was that when the GPS coordinates in the telephone were mapped, they actually showed the telephone about a mile from where the actual crime scene was. So I don't know what that means. I don't know if that means that the GPS software needs some tweaking. I don't know what that means in terms of the defense, but it will be interesting to see where the defense goes with that. And the final witnesses for the day were the eyewitness witnesses from yesterday. The final witnesses yesterday were the eyewitness witnesses. So there were 3 young girls, high school age girls, that were on the bridge or on the trail during the time that Abby and Libby were there, and reported seeing Bridge Guy. What was fascinating was every one of them had a slightly different description, and in at least one case, described the guy differently in more than one interview. So I think this really points out how unreliable eyewitness accounts can be. First of all, eyewitness accounts usually um, uh, happen in a kind of a split second. And often, as in this case, the relevance of what a person has seen doesn't click until later. So, in this instance, the fact that they had seen this guy on the bridge and that he didn't respond when they said hello to him and greeted him um, didn't really become linked to Abby and Libby until they found out that Abby and Libby were missing and then ultimately found out that they were deceased. So you're viewing that fleeting experience through that lens. And certainly one of the girls said the guy was didn't answer us and seemed kind of gruff when he didn't answer and wasn't friendly and so yeah, that could have colored the way that I remember him. Maybe I remember his clothes dark because of that. Maybe I remember, so but the really interesting thing that came up during that testimony was, as you recall, the prosecution wanted to keep the sketches that were done, the police artist sketches that were done by these witnesses, out. And the judge ruled that the sketches were hearsay and they were going to stay out. However, this at least one of these witnesses talked at length about that she was the person who gave the sketch artist the information to create the first composite drawing. And that, I think, and Andrea Burkhart thinks, and I share that, opens the door to get those sketches in. See, the prosecution doesn't want those sketches in because neither one of them resembled Richard Allen very much. I think it's arguable that the one sketch that of the guy in the hat, perhaps uh, there's some slight resemblance or some passing resemblance to Richard Allen. All three of these high school girls said the guy that they passed was taller. One of them said, I'm 5'9" and he was taller than me. One of them said, I probably came up to his shoulder. One of them said he was taller than her. So they consistently all said that the person who they saw was taller. And Richard Allen's 5'4" on a good day. So um, there's a real big discrepancy there. Um, the 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 witness that the prosecution wants to hang their timeline on. Oh, um, back to the three high school girls. They said that they left at 2:15. They knew that that was why was because one of the girls had to go to cheer practice, and they had to leave by 2:15 in order for her to get to cheer practice on time. The video that was on Abby and Libby's phone of the bridge guy is at 2:13. However, um, Betsy Blaine, who is kind of the prosecution's star witness, places Bridge Guy uh, at the Freedom Bridge um, at 12:15 or at 2:15, and he couldn't. It is probably, I don't know, a 5 to 10 minute walk from the Freedom Bridge to where the girls were when that video was made. So I think Bob Mata has said this all along. The prosecution's timeline does not add up. The evidence, the witnesses, they do not support the prosecution's timeline. It just doesn't add up. And I think that the timeline is going to be very critical in determining whether or not um, the it's even possible for Richard Allen to have committed the crimes. So I think that's where we are with Delphi. I know it's incredibly frustrating for everybody that we're having to get our information about the case really hearsay style. We're having to rely on what other people are saying happened in the trial. We're not able to hear about it ourselves. So it's sort of amusing to me that the law is so clear that hearsay is doesn't have indicia of reliability because of reliability issues with I heard this, they told me that. Um, but that's the way we're having to get our information about what's happening in court because the public is being limited in access to the trial. So, and because I have spent so much time on Boone and Delphi, I haven't been following a couple of the other cases that we've been talking about. I did want to briefly talk about what is coming up next because I've been sort of trying to keep um, a, a running list of what is coming up each month. So in October, the 22nd, wait a minute, was that today? I'm so confused. Oh, it was yesterday, was Ashley Benefield's sentencing. And I didn't see what the result of that was. And then the 30th, Dee Warner, there is a pretrial on Dee Warner's case. That's the case where she was missing. Her husband was presumed to have been the person who did her harm. Her children brought an action, a civil action, to have her declared dead so that they could have access to her estate. And the husband was trying to stand in the way of that happening. He was later arrested and accused of her murder, and then recently, within the last 2 or 3 months, her body was recovered. And it was recovered on property and in a place that it was likely circumstantial evidence would be that the husband placed her there. I don't have anything on the calendar yet in November. In December, we have early December on the 2nd, we have the James Craig trial. And then in January, we have Larry Millette, and we also have Karen Reed. So those are the things that are coming up. And I'm happy to take questions at this point, chat about what we've talked about so far, and also entertain any questions that y'all may have on any of the other cases. So I guess let's take some questions. And yes, I still have winter allergies, fall allergies my whole life. Hi, Dawn. Dawn says, don't believe her version. Oh, I think this is Sarah Boone. Don't believe her version of the missing time at all. She didn't remember making the video, but she knows exactly what happened after turning the camera off. I can't argue with that reasoning. All I can do is report what the testimony was given in the trial and report what the legal issues were. She was allowed to testify as to the battered spouse defense, and her testimony was that she did remember what happened, but that she did not remember making the videos, at least immediately after. The next day, she didn't remember making the videos. Now, I will say my understanding of memory in general, and particularly substance abuse memory, is that there are times that people say, oh, I blacked out, I didn't remember that. And yet later will say, Oh, I do remember that. It's kind of coming back to me. So I, I don't know what that says about the way our brains work and how um, intoxicating substances interface with our brain cells and those things. I am absolutely not an expert on that, but I do know I have heard many times in many cases people say initially, I was blackout drunk. I don't remember that. And then as time goes on, things come back to them. So I can't say that's what happened with Sarah Boone. I'm just talking in generalities. So ultimately, it's going to be up to the jury to decide whether or not they believe Sarah and her testimony, and or whether they believe that enough of her testimony to create reasonable doubt. So that's what trials are for, and that's why juries are the finders of fact. They decide what they believe and what the truth is. Roz Ott. Did Owens lead his witness? There were contradictions in her testimony that were obvious. So, does that mean that Owens was suborning perjury? And if so, can this come back to bite them both? I don't think so in this case, and here's why. The prosecution, first of all, I think Owens um, addressed with Sarah that she did not tell the truth in her initial interview. So he made it clear that the statement that she was taking the position that her previous statements were not complete and in some instances dishonest. He also brought in the fact that on many occasions she had um, lied about how her injuries occurred in order to protect George. So it was clear that she said, I was not truthful when I made those earlier statements. What I am saying now is what really happened. So that's not really suborning perjury because what the the defendant is admitting, I previously was untruthful. Um, I think that there was a different level of that when it came to the Robert Tellis trial, where he was going to get up and stand up and say, I'm innocent. I did not kill Mr. Gurman. And I know for a fact that this was a plot brought by Compass Commercial Realty. That is way different because the the lawyer knows that that is patently untrue, that there is absolutely no evidence to support Mr. Tellis's contention that um, that that he's innocent and that there was a third party who committed the crime. That's sort of different than Sarah Boone saying, "Well, I lied, and now I'm telling the truth." um, because she alone is responsible for whether or not she is currently lying or telling the truth. Her lawyer has the right to rely on that um, as a possible explanation for the differences in the testimony. The jury has to decide whether they believe that that is the reason for the differences in the testimony, whether they believe her or not. But it's not suborning perjury in the same way that the Tellis trial would have been, which is why Owens was able to do the standard questioning and Sarah didn't testify in narrative form. There were some rumors flying around that she might be testifying in narrative form. That would have been disastrous because it would have looked a lot like Robert Tellis. She's not super able to stay on task unless she's got somebody there that's giving her guidance. So that would have been a much more difficult testimony. So, but that's a really good question. I think there's a difference, and there would in the lawyer for the on the lawyer's behalf, ethically, the lawyer would not be suborning perjury to put his client on the stand, knowing that the client was going to tell a patently untrue story for which there is absolutely no corroborating evidence. That's not the case here. Um, the jury is going to have to decide which of the evidence corroborates which story, but there is evidence to support Sarah's story. So, hi, Teresa. Do you think that Sarah's attorneys are doing a good job? At times they seem ill prepared, but seem to have gotten in a lot of key evidence. In general, I think they are doing a good job. I think that they had a a huge uphill battle in trying to prepare a case this serious in such a short time. When the judge said, "I am not going to give you any extra time, this case is going to go forward." Ms. Boone can have a lawyer, she can have a lawyer of her choice, and all of that is fine, but I'm not going to give you any more continuances. That was a difficult position for the lawyer to be in. And I think that with what the lawyer, the time, and with what that lawyer had to work with, I think he's done a very good job. I think that the experts that they called to testify today did an outstanding job. Now, it's going to be up to the jury to understand or to decide which of the dueling experts they believe. But I thought both of those experts were very practiced, were very, not practiced, but experienced. They were very experienced. They had the facts of the case and the facts of their expertise right at their fingertips. And I thought both of them were very well prepared. So uh, I think that given the time constraints, I think that Sarah's attorneys are doing a very good job. Here's the other thing. I think they have done a very good job with Sarah. They did a good job getting her ready for her testimony, and they have done a good job of making a point of consulting her at every turn. This afternoon, um, Owen said, "I believe that we're prepared to rest, but before we rest, I need to meet with Sarah and I need to have a conversation with her about what witnesses we might have called that we're not going to call and about the trial strategy before we rest, because I need her to be comfortable with those strategic decisions." So the judge has been excellent about asking Sarah at every turn, "Are you still satisfied with your lawyers? Do you have anything that you want them to do that they're not doing?" So he's done a very good job of making that record that's going to make it much more difficult for Sarah to come back and say, "I had ineffective assistance of counsel because they didn't have enough time." So he's been doing a very good job of that. Her lawyers have also been doing a very good job of that. They have done a good job of walking that line of being the expert who decides the trial strategy with involving a client who is pretty needy. So I think if from my sort of outside view, I think they've done a good job. I think both lawyers, I think both sides have done a good job. I think the prosecution's done a good job too. The prosecution has a lot more at their disposal than the defense does. And that's true in every case. Um, it's just true in every case. So, good questions. I'm kind of curious to hear what you all have to say. What do you think her attorneys, how do you think they've been doing? Hi, Sharon. What burden of proof does the state have? Is it beyond a reasonable doubt? In every criminal case, it is beyond a reasonable doubt. Now, what I will say is that in the case of a self-defense case, there is a little bit of a shift of the burden. But if a defendant claims self-defense, then it is the job of the prosecution to prove that that person did not act in self-defense. Hopefully that's clear. And so the burden of proof does not shift. The state still has to prove beyond a reasonable doubt that Sarah Boone committed the crime and that there was no justification for the crime, which is what a self-defense defense is a justification for why the crime happened. So even though there is a self-defense defense posited, the prosecution still has the burden to prove beyond a reasonable doubt. So, good questions, as usual. My smart, savvy community. And on Sarah Boone, will the state be able to bring in JT's injuries from domestic violence? George Torres's. Yes, in fact, they've already, some of those have already come in. And Sarah has confirmed, and part of the wrangling that was going on before the trial started over medical records was whether or not George Torres's medical records were going to come in to show that he also had injuries. And I think we're going to see those in the rebuttal case. So one of the issues was you can't make George Torres's character an issue under the rules of evidence unless you've opened the door to the battered spouse defense. So it had to sort of happen in that sequence of events, and it all had to happen in the right sequence. It did. They did show that inciting event, George's hand reaching out of the suitcase and him making verbal threats. That was enough for the judge to say, okay, that door's been opened. That means that George Torres's alcoholism, his propensity for violence, past acts of violence, all those things come in. But that's a double-edged sword because all of the mutual combat injuries or the injuries that Sarah caused George also come in. So I think we're probably going to see those. We saw some already come in, but I think we're also we're going to see more of that in the state's rebuttal case. I think they're holding that back for rebuttal. So, and the rebuttal case is supposed to start tomorrow, and the defense said they were anticipating resting tomorrow morning after they had an opportunity to talk to Sarah and also to get those restraining orders in. So it appears they're going to rest in the morning. They're going to, the state's going to put their rebuttal case on. They were hopeful it was going to finish tomorrow, and then they'll have their jury instruction conference where they'll sit down and hammer out exactly what the jury instructions are going to be. Now, the judge has been working on that all along. There was some discussion of it today having to do with the judge redlining, as he called it, the jury instructions that noting things to have conversations with both parties about. So they'll have a jury instruction conference, hopefully tomorrow afternoon, and then closing arguments on Friday. I presume that that will mean that that the jury will get the case on Friday and will deliberate over the weekend. But the judge could decide, as we saw in which case did we see that in recently, where the judge charged the jury and then they didn't actually start deliberation until Monday morning. So either one's possible. I expect this judge is going to want to get this case before the jury, so they may deliberate through the weekend. So we'll all be watching. Question: what's the conflict of interest? Was it to do with payments for her defense team? And can you break down the finer point of the latest jury instructions? Okay. So I have not seen all of the latest jury instructions. The trickiest jury instruction, and I made a note to pull it up and look at it, but I didn't get an opportunity to do that before we started this evening. The trickiest is going to be the battered spouse self-defense jury instructions. So my plan is to pull those up and take a look at those. If it appears that that this case is going to go to the jury, you might see if it appears this case is going to go to the jury on Friday and that they're going to deliberate over the weekend, you could see a special surprise live about the jury instructions. Or you could see a newsletter about the jury instructions. It's been kind of crazy around my world trying to get time to sit down and do deep dives into legal issues in the newsletter, but I am still committed to doing those things. And so that could be a good subject for a newsletter, depending on what the intricacies of those jury instructions are. But I would be happy to do that. I'm not sure about this question about conflict of interest, and was it to do with payment for her defense team? I'm not sure what that's about. I don't remember hearing anything about a conflict of interest. My understanding is that her defense team is working pro bono. I also understand that the state is paying for her experts, and that could be pretty typical, even if an attorney is, and even in some cases, if an attorney is retained, um, the the state could and should, in many instances, still pay for experts. So it may have to do with payment of the experts, but I don't recall hearing about conflict of interest. So if you all have information about that, or have a clip or a timestamp that you want me to take a look at, just drop it in the comments or in the chat, and I'll look it up. Um, I I did see a quick reference to um, the judge commenting that what the defense was seeking was prosecution work product, but that wouldn't have anything to do with a conflict. So I can't, I don't know. So if you all will let me know a specific, I'm happy to look it up and to talk about it. So I'm curious if she will hear Andrea Burkhart's motions. Oh, good question, Carrie. So Andrea Burkhart has done something similar to what I did in the Vallow Daybell case, and that's that because she is a lawyer and she has filed a third-party request for access to transcripts and access to be accessed the same as the media. And Andrea said, I expect she's not going to hear the motions before the end of the trial because she knows my next step will be to appeal and um, and to press the issue. So as I did in the Vallow day bail case, because I was a lawyer and I know how to file documents, I filed motions to unseal the stuff that Judge Boyce had sealed improperly. And to date, to this day, Judge Boyce has still doubled down and kept all those things sealed. He now claims that it is because Lori has appeals pending and because she has other criminal charges pending. But I haven't given up on that, and I don't think Andrea Burkhardt is going to be giving up on getting those Delphi documents either. So I don't. I think Andrea doesn't think that Judge Gull will hear those before the end of the trial, and I suspect she won't. If you remember, my motions were pretty far in advance of the trial, so I don't think the judge had any choice but to hear them. But in this case, I think that she's certainly got the option of not considering them till after the trial's over. But this is sort of interesting. As we have more lawyers who are creators and are following these cases, we have more people who know how to intervene in these cases and find a way to get to seek accountability from courts that are not following the rules. And it's pretty clear that Judge Gull has not been following the rules. So, great questions, guys. Anything else for me? Oh, hi, Carol. Can the press file a grievance against the Judge Gull's decision to keep the press out of her courtroom versus Freedom of the Press Bill of Rights? So this has been a point of contention for quite a while, and a lot of it depends on the state statute. If you recall, and I don't know for sure, but if you recall in the state of Idaho, the state statute says that the trial judge has absolute decision, is the absolute decision on that, and that those decisions are not appealable. So it depends a little bit on what the Indiana statute is, and whether or not the press can continue to object or file appeals to her rulings. But I suspect that it isn't really an appealable ruling. So there isn't really a grievance that they could file to try and overturn her decision. Yeah, it's unfortunate, but I think that there is, in most states, a move to say the trial judge has the ultimate decision-making responsibility, and that ultimately it's the trial judge's final say. So, very unfortunate. Why do the judges do this? Well, I have a couple of theories. One of them is that I think they personally do not like the publicity. They personally do not like being that far into the public eye. It's one thing to preside over a courtroom full of people. It's another to have every eyebrow raise and everything you say transmitted and preserved for eternity and transmitted to millions. That's different than what many judges sign on for. So I think it's a combination that some judges are more particular about their privacy and about the fact that they don't want to have their face and their words broadcast all over the world. And I think the other thing, and I think this is true in Judge Gull's case, the fewer eyes on her, the fewer people are going to have information that they can use to point out her biases. And I think ultimately Judge Gull is one of those people whose answer to everything is because I said so. And that's not really a great way to conduct court. I will say about the judge in the Boone case, this judge is very personable. He is very amenable. The one thing he does that kind of bugs me a little bit is every time somebody in the courtroom sneezes, he says, "Bless you." And it's a very kind thing to say, and it may line up lovely with his faith, but it really does sort of interrupt the flow of questioning when the judge suddenly turns around and says, "Bless you," um, responding to something happening in the gallery. So, but he is very thoughtful. And I saw today on a couple of occasions where one of the lawyers made an objection and he said, "Approach." And then they went back to the counsel table and the lawyer renewed their objection. He said, "Approach," and he overturned his initial decision. And in both cases, because I sort of had a sense of what I thought the objection was, I thought that he was right to rethink his decision and to say, on further consideration, that is going to be overruled or that is going to be sustained. So I like a judge that is thoughtful and is willing to say, explain to me what I the what in a way that maybe I didn't understand, or maybe I didn't hear it the way you heard it. So I think the most frustrating is a judge who, um, like Judge Gull, says, "I'm the final arbiter. I have all the answers. I'm always right," and and then goes out of their way to belittle and make look foolish lawyers. Um, when I was practicing, we had a judge who was newly appointed to the bench. He had done really predominantly civil work all of his career. He had never done any criminal trials, and he had very limited trial experience. He was, in my opinion, more of a political appointee than he was um, a, an appointee because he was a good legal practitioner. And unfortunately, he was also one of these people who covered up their inadequacy by being blustery and angry and never being wrong. On the other hand, I also had a lawyer or a judge in my career who began practicing in an area that she had not practiced before. She had done some criminal and some civil work, but she had never practiced in the area of child welfare cases. And what I really appreciated about her was if she felt that she wasn't clear about some legal point, she would say, "I need to see lawyers in my chambers." And she would call the lawyers in and she would say, "Help me understand this." And each of the lawyers would then sort of explain their side and their understanding of what the law was. And she would go out and take the bench much better informed. And I think that that is a really admirable trait. And I see that very much in the Boone judge. He certainly takes a little bit more of a collaborative approach with the lawyers and not a because I said so approach. And I think that that ultimately means that the case is going to get tried in a more efficient way and in a way that where everybody sort of settles on what the law is rather than having an argument about what the law says. And I see Judge Gull as being much more of the combative because I said so, go sit down, you don't run my courtroom kind of lawyer or kind of judge. And I'm not sure that that kind of judge is the most effective at trying cases. So I think there's an interesting contrast. I wish that we could see Judge Gull because I think it would be a real marked contrast between her and um, Boone's judge, that whose name just escapes me right now. So these are all great questions. Oh, um, Tiff Knox. Hear, um, I did hear something about this. Just Bob mentioned that he had a seat. Um, Bob Mata is sitting with Richard Allen's wife, Kathy Allen, in one of her allotted seats. That was nice of her. I do know that he appreciates it. I do think that Bob has been a little bit more, just as Andrea has been filing motions to get access to the court and access to court records. Um, Bob, early on in the case, now remember, Bob and Allie practice in Illinois, right next door to Indiana. Um, Bob was helpful in helping start a GoFundMe campaign to fund some of the court experts when Judge Gull wouldn't approve money for experts. See, that's the kind of stuff that's just shows this unmitigating bias. I mean, how do you not approve the defense's expenditures for experts? That's that's actionable. So I know Bob was involved during that time with helping to um, publicize the GoFundMe campaign to raise money to pay experts, and I know that he also was involved with some of the lawyers that filed all the motions back to the Supreme Court to get um, Baldwin and Rosie reinstated. So I know that he has at least some relationship with the Allen family. And so I'm glad that he's got a seat with them because now he's not having to stand out at 2:30 in the morning and wait to get in with Andrea and Lee. And it's one less person who has to stand in line and take up space in that queue. So, um, and Andrea says she's trying to take care of herself, but that's grueling, and I don't think it's sustainable for any of them. I don't know how they're all going to do it, and I think if they were smart, they'd figure out a way to work together and take turns attending because it's going to be grueling, and this trial is going to go on probably a couple more weeks. So. Good questions, everybody. Have you seen any of the trial of Melody Ferris from Georgia? I've seen some of it, bits and pieces of it. This is the woman whose husband's body was found burned in the burn pile. He was a lawyer. They had a hobby farm, and they had a very difficult, conflicted marriage, and they each were involved with other people at different times. Um, and there's seems to be some pretty ample circumstantial evidence that she was responsible for his death, and she is on trial. So I am going to try and catch up on those over the weekend. The trials that aren't immediately going on, that aren't Boone and Delphi. I'm going to try and catch up on those over the weekend. So I hope I will have more to talk about next Wednesday when we do True Crime Wednesday. I think we'll probably know a little bit more about what the court's going to do about Lori Vallow's competency motion. I think we'll know a little bit more. We'll know some more about some of the other cases that are pending. So, other questions? Hi, Bo Peep. You know, we haven't seen Trisha the Trucker lately. So if anybody's seen Trisha the Trucker, tell her to get in touch. Bo Peep. I was confused about the judge's explanation when he talked about how law enforcement is allowed to start taking Sarah's statements before Miranda or something. It was how he stated it for instructions. Oh, okay. So initially, there was a motion to suppress complaining that there was a line on the Miranda card that the police officer who originally Mirandized um, Sarah Boone had not read. And so the judge had to decide whether or not that particular statement, which was understanding all of the rights that I have read to you, are you still willing to talk to us? The judge found that the case law did not support a finding that that was a Miranda violation. The fact that the police officer had not asked Sarah Boone whether or not um, she was asked if she understood her rights, and she said yes. But the officer didn't then follow that up by saying, understanding all those rights, do you still want to talk to us? The judge found that that question was not necessary. However, he added a line into the jury instruction that said if that the jury can give whatever weight to that question not being asked, um, that they think is proves any kind of coercion. So let me see if I've said that right. What the judge said was that the jury could consider and decide what weight to give the fact that the police did not ask that question. So they added that line into the jury instruction, which I thought was kind of odd because the judge said the jury is not required, um, the police are not required to ask that question. Not asking that question um, doesn't disqualify Miranda. Doesn't um, I'm running out of words here. Doesn't nullify Miranda. So the fact that they didn't ask that question didn't nullify the Miranda warning. That was still a good Miranda warning, and she still said she understood it. But the judge kind of hedged his bet by saying, I'm going to add this line into the jury instruction that says that the jury can give whatever weight they find necessary to the fact that the police didn't ask that question. So I don't think it's going to make a whole lot of difference because the jury's going to say, okay, she got Miranda, she understood it. The fact that they didn't ask that question, the judge isn't saying that's fatal to Miranda. We get to decide whether it was important or not. So, did I hear something about the Reed jury issue going to a higher court for appeal? Hi, Beth. I don't know, but I'm presuming so. The last I heard, they had finished their brief, and the appellate court had said they were going to hear it and had accepted it. And there was some discussion about whether or not the appellate court was going to hear the appeal on the double jeopardy issue before her trial starts in January. So I think that that's where we stand, is that the defense filed their intent to file their appeal saying double jeopardy should have attached to the two counts that the jury found her not guilty of, but didn't report in their verdict. And the defense filed their opening brief on why they think the court should dismiss those two charges. And the appellate court accepted the brief. The question is whether or not the Commonwealth's going to get their brief and they're going to be able to schedule. It seems to me like they've got time. Usually briefs are due in 30 days. So it seems to me there's time for them to actually schedule oral arguments on that issue before, and perhaps issue an opinion before her trial in January. I think that's kind of where everybody's hoping it's going to go. At least I think the defense is hoping that's where it's going to go. So I think I don't think there have been any other developments in the last couple of days in the appellate process, but I'll double check. Well, we're just about out of time. Anybody have one more question? If not, we'll start wrapping up. I do want to remind everybody, first of all, I want to say thank you, thank you, thank you to all of the people who have posted reviews. We have exceeded the Amazon 60 review point, and I am so appreciative of that, because that means that Amazon starts, it gets into the Amazon algorithm, and they start recommending the book to people who have ordered or read true crime books in the past. So that's a huge accomplishment, and I appreciate every one of you who posted your reviews. I also know there were a ton of reviews on Goodreads, and a lot of people posted their reviews on Audible. I've gotten a lot of positive feedback on the narrator that we chose for the Audible book, and I'm really happy that you have enjoyed her work. I've heard nothing but good reports on her narration style. And so if you would like a book plate, a signed autographed book plate for your book, please email me with your address. Nobody wants to put them in the comments or in the chat, but my email is in the chat. I have been very faithfully sending out thank you cards, stickers, book plates. So if you would like to have one, please drop your address to us directly by email. Your address does not go anywhere except into my email file. We are not sharing that information with anyone. But it is a great opportunity for me to drop you a little thank you for your support. So thank you so much for everyone who posted their reviews. Thank you for all of those who have ordered the book, read the book, are going to read the book. A couple of people who I got messages from said they were, one said they were having a staycation this next week and they were looking forward to diving in. Another said she was headed out on a cruise and she was looking forward to taking it with her. So I appreciate all of your support. I have some local Pacific Northwest, Central Oregon book signings coming up. And I was going to try and get over to Idaho in early November, but we couldn't line up everything so that I could make it all in one trip. So we've decided that we're going to schedule the book signings in Boise and McCall in the March timeframe. My publicist is working now with Rediscovered Books, working on setting some dates there. And I'm going to be over the week of Valentine's Day. I'm going to be in the Phoenix area for a little bit of spring baseball. And during that time, I've let my publicist know that I'd be available to do a book signing there. So I'm hoping that we're going to get something set up there. And you all can let me know if you have an independent bookstore in the area that you would like my publicist to approach about a book signing in the Phoenix area. So all of those things are going amazing. I can't tell you how much I continue to appreciate all of your support, how much I appreciate Jen, our moderator, and what a great job she does. and how much I appreciate our true crime community. So I just want to say thank you so much to all of you. Have a lovely week. If we get interesting movement and information in the Boone case, there could be a surprise live coming up. So be sure that you have subscribed and hit that notification bell. And we do know that sometimes YouTube drops subscriptions and sometimes YouTube drops those notifications. So if you haven't checked that in a while, be sure and check that out. And with that, I'm going to say good night. Have a great week, and we'll see you next Wednesday. Good night.